And joining us on debate number 2 on the News Hour tonight, Sujay Kantawala, senior lawyer joining us from Mumbai, believes death sentence was a little too harsh. Sumit Verma, advocate, joining us live from New Delhi on the same side with Mayank Gandhi, activist, also from Mumbai. But backing the verdict is Purnima Advani, former chairperson of the NCW. Live from Mumbai today, Swapnil Kothari, corporate lawyer and managing partner, live from our studios in Mumbai. Brinda Adige, director of the Global Concerns of India. And let's start with one picture that speaks about the story that we're talking today. The picture on your screens of a murderer, of a man who threw acid on Preeti Rathi. Ankur Panwar has been sentenced to death, and that was him yesterday after the verdict, flashing a victory sign. And that's why we're debating this today with those who feel that's a little too harsh, starting with you, Sujay Kantawala. Saying no to death sentence in this case would mean you are being sympathetic to a criminal, being sympathetic to the perpetrator of the crime. Now, Sujay Kantawala, tell me, why should the eyes of justice be sympathetic to a criminal who's killed a 23-year-old by throwing acid on her? Yes, it's the first time that death sentence has been handed to someone who's been involved in a case of acid attack, but it's still rarest of rare.
Look, in the criminal justice delivery system in our country, revenge is not the criteria. What you're now talking about is revenge. Revenge is not the motive for which justice, we are seeking of justice, judgment. So justice is what the society generally would expect. And according to me, if it is seen all over the world, and there have been debates, there have been many surveys done, and one has now collated a lot of evidence, and it is now proved that this kind of a revenge, that capital punishment, does not reduce this sort of crime. So what we need to now actually think is, how can we start some kind of a movement where these crimes can be reduced? Because every time we talk about it, that, okay, capital punishment.
Let
me complete.
Are you saying it's not rarest of rare?
No. Rarest of rare. In fact, there is no straitjacket formula for rarest of rare. The Supreme Court.
Okay, by your definition then, this is not rarest of rare because he purchased the acid beforehand. That. No. You are saying. You're saying that it's not definitive.
May I say this?
Okay,
Sorry
go ahead.
To interrupt you.
Okay.
The judge has to give her judgment as to how and on what basis and what are the reasons that she is going to call out in the judgment which is going to be available on 16th. So let us first await the judgment. What are the reasons and why she has classified this in the rarest of rare cases? So let us respect that view.
No, but prima facie,
let us then discuss that view according to me.
Prima facie, I think you'll believe that, from whatever has been reported in the media, and for 3 years now, the facts have come to the fore.
Yes.
And let's consider this: 2 liters of sulfuric acid thrown on a girl's face for 1 month, she suffered. And you say it's not rarest of rare.
No, 1 minute.
You think it's not reason enough?
I'm here as a lawyer on this debate. What has happened is abhorring. I agree. This was not to be done. A young girl has lost her life. I agree with all that. But the Supreme Court again and again has given judgment after judgment. There is no straitjacket formula.
Correct.
For rarest of the rare cases.
IPC 326A awards up to life imprisonment.
Yes.
Has that deterred people from throwing acid?
Exactly. That is what I'm saying.
That has not deterred people from throwing acid. So if it has not deterred people from throwing acid, and if these guys think that they can get away with it, there has to be something harsher, Purnima Advani. And if it is a death sentence, so be it. It should be harsher. But because we are a democracy and we want to be civil, so we say death sentence. Yes, Purnima.
Look, I believe this program is not on the larger issue of whether capital punishment should remain in our law books or not.
Correct.
The point is here that if capital punishment, death penalty is a part of the Indian Penal Code, then do we classify acid attack resulting in death as the rarest of the rare, yes or no? I think it's a question of perception. I completely disagree with the earlier speaker to say it's not rarest of the rare. In fact, I think the message should be loud and clear that society is not going to tolerate such heinous crimes against women, and this is as serious as a crime of rape. I would put it both at an equal pedestal.
Swapnil
and
Kothari.
Therefore, I'm saying that it's extremely crucial
right,
that the message should be. The other point is
right.
the time taken to deliver judgment. I wish now that the High Court and Supreme Court do not cumulatively take 20 years to deliver the judgment. It should not be diluted. That's very important. The message should be loud, clear, and specific so far as
And the
timeline
justice
is
should be
concerned.
speedy. The pronouncement of the verdict should be speedy and not delayed. Swapnil Kothari, Sumit Verma, contrarian points of view. Swapnil first, then Sumit. Yes, sir.
What Sujay is saying is, what Sujay is talking about is the reformative aspect of justice. What I'm talking about is retributive justice in this particular scenario, because this is a completely rarest of rare case. 2013 amendment enacted 326A, 326B in the light of the current global scenario where people are becoming more and more assertive, when they are spurned, especially somebody like Ankur, you go and throw acid at someone, that person suffers for a month and eventually dies. What does that mean? That means clearly that you need to have and give appropriate punishment to the person who has meted out that kind of a treatment to that girl in question. So the retributive aspect is as important as the reformative aspect. It is retribution here, and the Supreme Court may not have enunciated a straitjacket formula, but at the same time, the death penalty exists on the statute book. I am not here to debate whether the death penalty should be there or not. The fact remains that, like in Iran, you would put acid in the eyes of the person who perpetrated that kind of an attack. Similarly, you need to do the same thing here. We don't do that here because we are a democracy. That's why we send the people to the gallows.
Yeah, we're relying on the judiciary. We're relying on the judiciary, and when you talk about rarest of rare cases, and Sujay Kantawala brought this point, but I want to go across to Sumit Verma. Sumit Verma, consider the fact that the Supreme Court, in the Bachchan case, I think you remember, it said specifically, taking into account the answers to the questions posed by way of the test for the rarest of rare cases, because we're talking about the rarest of rare cases, the circumstances of the case are such that death sentence is warranted, the court would proceed to do so.
Yes.
Yeah. What's your take?
May I just
Of course, you disagree. Yes, go ahead.
Yes. Bachchan Singh's judgment does not merely talk about rarest of rare principle, it also propounds a balance sheet theory of aggravating and mitigating circumstances. And one of the most significant mitigating circumstances enlisted in Bachchan Singh's judgment is whether an accused would be a continuing threat to society and whether a convict can be reformed or rehabilitated. And in Bachchan Singh's judgment, which is a constitutional bench judgment, Supreme Court categorically says that the state has the onus to lead evidence and prove that the accused, that the convict is beyond any reformation and rehabilitation, and that he would be a continuing threat to society.
Correct.
The point I wish to make is that even if we come to a conclusion that the facts of this case are rarest or rare, the judge has returned a finding of death sentence. Death sentence has to be in accordance with the principles laid down in several judgments of the Supreme Court. Supreme Court time and again has laid down that in order to return a finding of a death sentence,
somebody who's flashing a victory sign after the verdict has been pronounced. Somebody who's flashing a victory sign after the verdict has been pronounced, he makes aggressive gestures at one of the family members of the Preeti Rathi's family and smiles, continuously smiles at them and then threatens them of dire consequences when he comes out. Should not be a threat to society.
So
this is murder in cold blood, Brinda Adige. He planned the murder. He travelled with her from Delhi to Mumbai. As she stepped onto Mumbai, because he said you will not leave the national capital, she steps onto Mumbai. He taps her from behind the shoulder and throws 2 liters of sulfuric acid on her. And it also falls on her family members and people around. That is not calculated cold-blooded murder. That person is not a threat to society. Anybody and everybody who throws acid once can go ahead and do it again. If that person is let out in society, so what's the guarantee that person will not do it?
Death sentence for such a acid attack victim. All I am saying is that the facts of a case, howsoever grave they are, would not absolve the prosecution of its onus to lead evidence to show that the convict is beyond any possibility of reformation and rehabilitation.
Correct. So the judge has taken into the honorable bench has taken into consideration the arguments made by the prosecution, the accounts of the eyewitnesses, and also the statement of the father who comes out and says that at the police station he confessed to throwing acid. He said, "How dare she spurn me and go ahead and leave the city." Leave me and go, I will not let her. Yes. And he says that he did it. Though after that he continues to change his version and he's maintained a different version altogether, Ankur Panwar. But this is what Preeti Rathi's father had to say. Brinda Adige.
The Supreme Court of India,
that the rate of recidivism among people of this nature is very high, especially those who commit murder and crime. And this person clearly falls within that purview. There is no other argument. In this purview, this person cannot claim anything else. Capital punishment in this special instance is the ultimate and significant deterrent, especially considering possible potential
The
victims.
question is whether he has been granted death sentence in accordance with law and the principle laid down by the Supreme Court. The question is, what is the purpose of granting a death sentence if it is not to be upheld by the High Court or the Supreme Court? Ought to have taken care
We see
of
across the
principles laid down by
country
the
when
Supreme Court
crimes
in
are
number of
committed
judgments.
on women, everybody wants to be sympathetic to this man.
Certainly not.
With the
I
impunity
say he
with which
deserves a
this
death
crime is
sentence. He should have been
committed
meted out
is
death
never
sentence,
questioned.
but in accordance with the principle laid down by the Supreme Court.
Sir,
Supreme Court time
no,
and
no,
again
so
has said and reiterated
Brinda
that
Adige's
in
point of
case-
view is any punishment short of capital punishment is being sympathetic to that person is what Brinda Adige's point of view is. Sumit Verma. Yes, Swapnil. Yes,
On the
Swapnil.
contrary,
Why don't you
death
empathize
sentence
with the
in order to be
victim?
maintained
Why
and not
don't
to
you
be upheld
empathize with the
has to
victim's
be- has to
family,
be-
her friends, loved ones?
Live imprisonment.
To me-
without
No,
bail.
no, I'm sorry.
Yes.
No, no,
I
no, no.
also
I'm
agree
sorry.
that
No.
capital punishment
Brinda-
appeal should be shorter.
Yeah,
Punishment
Brinda, I'm with
should
you.
be
Brinda,
severe
Brinda,
and
I'm
swift.
Brinda, I'm with you. I'm just trying to add to what Sumit had said and maybe differ. Sumit, with due respect, I differ with you a little bit
I'm
here.
yet to complete
Sumit,
the
can I
point.
complete, please?
Just
Sumit,
10 seconds more.
Sumit, please. Sumit,
I was
please.
only
I've
referring
heard you.
to a
Give us
judgment
10
of the
seconds.
Supreme
10
Court,
seconds.
Anil
Okay,
Anthony.
quickly go ahead. Yeah. 10
Yes,
seconds, quickly.
Supreme Court in Anil Anthony of the state of Maharashtra has held that the facts of a case, howsoever grave they are, should not be the basis for reaching a conclusion whether a man cannot be reformed or rehabilitated. The state has to lead additional evidence both for and against the possibility of rehabilitation, and thereafter the trial court has to return a finding whether a man can be reformed or will he be a continuing menace to the
Yeah, got it.
society.
Swapnil, Swapnil.
Only
No, no,
then will
no, no.
death
Sumit,
sentence be
Swapnil, coming to you.
confirmed by the High Court and could be upheld by the Supreme Court.
No, one of
What
the
is
arguments, Swapnil.
So what are you trying to say, Sumit?
Sumit got your point.
Sumit, we got your point. Sumit,
got your point.
It is violative.
Okay, got your point.
Sumit, I got your point.
Yeah.
Sumit, I got your point. So what are you trying to say, that the principles enunciated by the court suggest that we need to decipher first or discern first whether the person is capable of being reformed? So we'll have to wait for 5 years, check his behavior and see whether he waves any victory signs out of the jail or not.
No,
And then decide that no.
Sumit said whether the procedure has been followed. By what Sumit meant was that the prosecutor is not a convictor. The Supreme Court says the job of a prosecutor is not of a convictor. He is an officer of the court. He has to assist the court to come to the pros and cons of the whole issue, and thereafter assist the court to deliver judgment. The judgment is coming on the 16th.
And he has
Let
to
us
lead
see on
evidence
what basis
both
the
for
judge is
and
giving
against
this.
the
What basis? I mean,
rehabilitation.
I think there's enough basis. Yeah, Sujay Kantawala, I think there's enough basis. You know, 1 second. I think there's enough basis, and I'll tell you why. I'll tell you why. Brinda, let me tell him why there's basis.
Right.
The fact that the court itself has noted that this case is more brutal than rape. It's more brutal than rape. How does any argument, and Sumit, this is to you, and Sujay, this is to you as well. How does any argument warranting sympathy for this, you know, if I can call him psychotic and a twisted mind? No, what does the court said? What does the court said? Okay, what does the judge said? What does the judge said? Rape destroys the soul of the victim. She can be kept in isolation without disclosing her identity and be rehabilitated. But for an acid attack victim, she has to move around with her destroyed body.
Absolutely. The
Sujay,
whole idea was to name. That was the entire idea.
Then why are we arguing on whether
I fully agree that these are the sentiments of the court. But let us see as to how and on what basis.
Sumit, let's resolve.
By the Supreme Court number of judgments, and categorically in Anil Anthony what has been laid is that the facts of a
Purnima
case
Advani.
will not govern whether a man can be reformed.
Okay.
No.
I'm not even on reform.
Purnima.
I'm not here. I'm not writing a brief for reform.
No, watch it.
That the people have
Hang
reformed.
on. Just one at a time, please. One at a time, please. Sumit, I'm going to bring in Purnima Advani and Brinda Adige one by one.
Defamation.
Brinda Adige, 1 sec. Yeah, Purnima, you had a point to make, and then we'll go to Brinda Adige. Brinda Adige, please wait.
How serious?
Yes,
serious
Purnima.
is it?
Yes, Purnima.
The question here is not whether prosecution has to lead evidence. I'm sure all the procedural aspects of law have been complied with. The point here is, how do we view an acid attacker? In which way is he different from a person shooting at a person and murdering, and a person throwing acid, distorting the entire person, and the person ultimately dying? It is as serious as the former, and there is no difference between the two. The ultimate result is death.
Yeah,
It is for the
Mayank
court
Gandhi,
now to decide
Mayank Gandhi.
whether it is murder or culpable homicide, not amounting
Mayank
to
Gandhi,
murder.
come into the debate,
But
please.
barring that, there is nothing. It is nothing short of an action causing death.
Absolutely,
Mayank
he's a
Gandhi.
perpetrator. He's a perpetrator. Point taken,
Question
Purnima Advani is a
not whether it fall under
perpetrator.
murder or culpable homicide.
Sumit, let
The
Mayank
question
Gandhi
is,
come in.
having returned
Sumit,
a
let
finding
Mayank
of
Gandhi come in.
murder, whether he can be granted a death sentence.
No, got it,
Therefore,
got it.
what I am
Sumit,
saying
got
is
your point.
that
Sumit, got your point.
that at
Let
the stage
let
of
Mayank Gandhi come in at this
sentencing,
point.
The prosecutor was obliged under law
Don't
to
split
give
Mayank-
evidence to show that
Sumit-
the man is incapable of
Sumit, I request you-
information.
Sumit, I
And the
request you
judge
to
has
give Mayank Gandhi a
on the
chance.
basis of those additional materials.
Got it.
Not on the basis of facts of a case or material on record.
Yeah, you're saying the same point.
What the judge
Sumit,
has
you've been
quoted
sticking-
are material
You
on
have been
record.
talking about the same point, Sumit.
And the
Sumit,
facts and the graveness of the facts of a case.
got it. I request you to please give Mayank Gandhi a chance. Mayank, I'm asking you this question because you seem to
I think
differ with the verdict.
there is a consensus. Yeah, there is a consensus that this has been a gravest of grave charges. I do not subscribe to rarest of rare. I mean, it does not. How many crimes take place is not as important as how grave the entire thing is. So I would say it definitely is the gravest of the grave charges that are there. The question is not, being a legal person, I am going to say this. The issue is, how does a civilized nation look at this? There can be, eyes can be gouged, people can be cut into small pieces, stone can be thrown at him, or they can be hanged. My personal view is that it should be a strong deterrent, but it should not go up to hanging, so that maybe this
What is a
young
strong
person,
deterrent? What
however
is a strong
worse he is
deterrent?
and however he is smiling and
What is a
putting-
strong deterrent?
After
What
no,
according
a life
to you is a
imprisonment.
strong
Life
deterrent?
imprisonment behind bars.
rigorous
No, life imprisonment in a jail is a
Life
strong
is
deterrent.
sacred.
Whereas an acid attack victim, whose punishment is greater, sir? Whose life is going to be more miserable? No, sir. The straightforward
No,
question that comes
I'm
to
not
mind.
denying the fact.
Mayank
Please
Gandhi,
don't
please
take
answer
this
this.
into a
Who is not the person?
bloodthirsty group of
Sir, the
people who want
reality
this
is,
blood.
the
I'm
reality
saying
is,
here
sir,
a person.
I-
Maybe after 30 years he may reform.
No, the
You can
reality
give him a
is, sir,
chance. He's
20,
also a human
15
being
years,
after all.
20 years
However
behind bars in
misguided,
jail
however wrong he may have done.
is a
But
far
to kill
better
him by
life
a civilized
than the acid
society,
attack
I don't
survivor
think is
who
the-
has
is
to
the
live
right
the rest
thing.
of the life in society.
And blinded.
So how is
she's no longer a
maimed,
survivor.
dismembered, disfigured, and also
Are we talking about a deterrent, or are we
and she
talking
has to,
about tit for a tat?
sir, and the acid attack survivor has to relive that horrific episode every time.
No, I appreciate
Somebody,
that. There's no
every
need to
time she looks
push
at
that
somebody,
point further.
every
We
time somebody,
understand
every
that
time
an acid
somebody
victim is
reacts,
passing through a
every time
horrible
she looks
time,
in the mirror, she
is
has to
dead.
deal with it. That's the punishment that person has put on her for no fault of hers.
We all
And
understand
you are
that,
trying to say
which is
that
why
life
it is a
imprisonment
deterrent and which
is
why
is
you don't
punishment enough?
understand. You don't
So you want to be
understand.
humanitarian and civilized in a civilized society.
this
You want to
is-
think about
this
the
is like
offender,
a- this is like a
but the
Roman-
offense that is committed is the
Roman
gravest
thing
of
and
grave.
all the
No, you know what happens is-
waiting for
Liberal
blood.
He committed.
view.
Okay, Mayank, consider this.
Sound nice.
Brinda again, Mayank.
Yeah.
Imprisonment.
Yeah, Brinda again, Mayank, consider this. He committed the crime at the age of 25. He's 28 today. He will be a free man if three people on the panelists on this panel, Sujay Kantawala, Sumit Verma, Mayank Gandhi. No, one second.
Free man in 15 years.
Yeah, 15 years.
And then what will
40.
he do?
He will be out at 42.
Yeah.
Sujay, he will be out at 42.
Therefore, I'm suggesting something.
Yeah, he will be out at 42. This should be an example. Why is this case important? Because the acid attack victim suffered for 1 month and then she died. She died because of the acid attack. Should this consider
I'm appalled by it.
Correct.
I'm appalled by this.
Sir,
No, let's
sir, there
I'm
are-
appalled by it. There's no doubt about
Sir,
it.
there are reports which say
It is
that
just
she
enough
survived for
that
1
there
month
is
Yes.
because she did not look at herself. She was not. She did not know what had happened to
Very
her.
sad. Very sad. It's very sad. But
That's
listen,
not a
we
society
are just
work
now
to kill a
discussing
person
on the
just-
issue.
If he's done wrong, reform him, punish him, deter him. but
Yes,
don't kill
sir.
him. That's
What
the only
reformation
point.
are you talking about?
Where
Do you
is your
remember?
empirical
Do you
evidence
remember?
to
Do you
prove
remember in a parallel
how
case of
many have
in a
reformed as a
parallel case of a
result of the
juvenile who was guilty of rape,
reformative
Brinda Adige? That person ended up being radicalized in a juvenile home. That ended up that there are people who
No, he could
end
be
up becoming
castrated.
far
There
more
can be
corrupted
so
in
many
our
things
reform
that could be
centers.
done
So do you want to
short
send
of
this person
killing him.
so to a place where he can
You-
further flash the victory sign and
No,
smile, Brinda Adige?
No, I think this argument. This
When you
argument
make
is
your
ridiculous.
argument,
It is
make
either
your
he is innocent
argument
or he should be
in
killed.
today's
There is a way by
realistic,
which he
pragmatic
should be
world.
punished.
What
He could
reformation
be
are you
deterred,
talking about?
but still not be killed.
Systems
That's the
have
only
to be
point I'm
reformed.
making.
But you are being sympathetic only to the culprit. to the person who has committed this murder. You are not
because I
even being
say we should not be
empathetic to the
killed, but
victim,
something else
to her
should be done
family.
does not mean I'm
She is no
sympathetic
longer
to it.
here to talk about it.
No,
What's
this
the
is-
guarantee?
You are,
What's the,
you are having an
Not
argument
discussing
of
very black and
democracy
white.
and civilized viewpoint.
I think-
You are being liberal.
Swapnil, respond to Mayank.
This
let's-
liberal
let's,
thinking is
kill him by
good.
stoning.
But tell me
Let's kill
how
him by
you will look
stoning.
at
Let's
it
hang him
if
on the
this
nearest
was the
tree.
man who did something.
Let's break
God
his
forbid.
neck.
Nobody's
No,
paying for
no,
blood,
no,
Mayank.
no,
Your
no,
wife,
Mayank.
your mother.
Mayank, nobody's
Why
paying for
don't we
blood.
do that? The argument.
No, nobody's
You're
paying
not
for blood.
understanding
Mayank,
you're doing
Mayank,
this
we are not
into a black and white that if I
Please
don't
don't
kill him,
be-
that means he should be released and I'm being
Don't
sympathetic.
No,
think
he's
from
not.
an intelligent
I'm saying
point of
there
Okay,
view.
let's look at this.
Think
Swapnil,
about
Swapnil.
it emotionally. Think
Yeah.
about it with relationships. Think about it with your family in mind.
Mayank,
Okay, it's a simple debate. Swapnil.
Mayank, the question is not whether the death penalty should be meted out or not. The question is whether this case qualifies for death penalty. Death penalty is there on the statute books. There is
You leave
nothing
that to the
else.
court,
No,
boss.
let me complete, please. Let me complete. May I finish?
Of the grave crimes.
May I finish? What I am
Sir, there
saying
is
is
no
that
gravest of the grave, rarest of rare.
in absence of death penalty or as an alternative to death penalty, what do you suggest? Do we suggest gouging out the eyes? No, we cannot do that in a civilized society.
Exactly.
Do we suggest dismemberment? No, we cannot do that. Do we suggest a life imprisonment? Life imprisonment itself is not tantamount or is not sufficient justice for this particular case.
Rehabilitation is the only process.
Is the only alternative to this.
Exactly.
The other thing is what we do, what Bangladesh did a couple of years ago. We enact two legislations. One is Acid Crime Control
Yes.
Act and the other one is Acid Control Act. Can we control the sale of acid in this country of 1 billion people?
We can't.
The
We've
answer
tried.
is no.
We've tried,
So
we can't.
We've tried, we cannot. The other thing that we can do is to control,
So you have
acid
to
crime
have
control.
severe,
So how do you
significant
control the crime?
Question to Mayank.
So I am with you, Brinda. I am with you.
Yeah,
I'm for
question to
death
Mayank.
penalty.
Mayank,
I'm only
question to
trying
you. Question to you, Mayank. Since you say that we can look at other avenues to other ways of punishing this 28-year-old. Now we don't have any other way of punishing him.
Please do not give me this youth and young person with his life ahead.
Exactly.
You also
Brinda.
have to look at the youth and young person.
Brinda,
victim.
This whole
That's the
thing is
point.
like a Roman gladiator and everyone wanting blood.
Nobody's paying for blood, Mayank. I'm only asking you because your argument at the end of the day revolves around rehabilitation because it's the only process
you
under
know
the law.
that recidivism among
If not for
such
death
people is
sentence,
very
life
high.
imprisonment, and it
Research
comes back to
proves it.
rehabilitation. I'm only saying rehabilitation
I
is
have
not
confessed
a.
earlier that I am not a legal person, but I am
Not for this
in
case.
favor of a civilized nation like India. Like we are saying, we should not gouge the eyes because we are civilized. Like we say, we should not stone because we are civilized. I am saying, let's take it one further and say, let's not kill because. We are
Okay, let's not kill. Let's not
Short
kill.
of killing, there should be a lot.
Okay,
of
Mayank, in your own argument, Mayank. Mayank, your own argument. By your own argument, let's not kill him. Brinda, by his own argument, let's not. Okay, by his own argument, let's not hang him. Okay, let's not hang him. A person who committed a premeditated, cold-blooded murder.
Is not a 14-year term. A life sentence should not be misconstrued as a 14-year term. Life
Correct.
means
So that's the reality.
biological life of a convict.
Correct.
It is only that after 14 years he becomes eligible to be considered for the purposes of remission of sentence.
He
That
dies,
doesn't
let
get a
him die
right
in the
to be,
jail.
to be out of the jail immediately.
Exactly.
Therefore,
Exactly.
You cannot draw an analogy saying that
Give him hard labor,
no problem. He dies in jail.
What
Let it be
right
an
does
example
this
to
person
people
have?
that if you do something so bad and so appalling, you will full
This
life
is
you will
that
shut out in jail.
example.
You will rot in jail.
No,
This is that example.
Did 326A deter him from throwing acid?
Exactly. So the point is,
Did it deter him from throwing acid?
Right. I'll answer.
Did it deter him
Why
from throwing
aren't
acid?
our provisions, which are draconic, why they are not deterring people? Why they are not deterring people? Because the people feel that the long arms of the law will not be able to catch up to them. This is the whole problem. It's a general society issue. Why is crime rate not going down? It is going up day after day, again and again.
Why is there more awareness after the Nirbhaya gang rape?
Exactly.
Why is there more awareness?
Therefore, what
why did
we
the
need to
laws
do
get
is-
tougher after the Nirbhaya gang rape
We
case?
need as a society,
Because there were
as
new
a
laws.
society to take this.
Because what happens what happened post Nirbhaya gang rape case is an example.
Yes. No. Therefore,
Sujay Kantawala, let me ask
agree.
you this question.
Yes.
Acid फेंकेगा जेल जाएगा, acid फेंकेगा फांसी लग जाएगी. Which is a bigger deterrent?
I'll tell you. See, now for example, in this
Let me
case-
ask you plain and simple. Let me ask you this: which is a bigger deterrent?
So therefore, may I
which
only
is a
say-
bigger deterrent? In our country, till the time death penalty is there in the statutes, That's a wider debate whether or not it should be there.
So I would request-
If that is the biggest deterrent today as far as our law is concerned, why not that deterrent for people who don't think twice about ruining a person's life? They have not just disfigured them. They have dismembered, maimed them for their entire lives.
Anand, I fully
So there is so there has to be something which is a deterrent when
So
that
therefore-
person, when he picks up that bottle of acid to throw it on somebody, there is a thought in his head that saying, I am also going to go.
Right. So therefore, Anand, I would request you till 16th, please wait. I want to see what the judge is giving, what reasons, as to how and on what basis.
No,
she
but
has
what-
thought
what more
to,
reasons do you
award
want?
the death. See, because what her mindset was, we don't know just now. Let us see what reasons she
Sir,
has
the
given.
mindset
the
was this.
mindset. The
Mindset was
mindset.
this right through the course of this entire trial, Swapnil Kothari. Not one word of remorse. There has been not one expression of remorse or guilt. There has been not one word that, oh my God, what have I done? There is not one word of repentance. So if somebody in 3 years after being sentenced to death flashes the victory sign and then challenges and threatens the family, are you trying to say that you're going to be able to reform him? Who's going to take that person's responsibility in society?
I'm not willing.
just-
I'm
just
not
to-
arguing for reforming him.
No,
I don't
just-
want to reform him. I want him to rot in jail for the rest of his life.
Why should that-
As an example
Why-
to whoever tries to do this, that
Why?
example, the state
Why?
has to say that he will rot in jail.
Next
There will be
one.
hard
Brinda
labor,
Adige,
no
counter.
parole.
Brinda Adige, counter.
Set it as an
So
example.
what happened? We saw what happened
You
to a
cannot have
murderer.
revenge.
No, we
My
Sir,
friend,
I
you
have
cannot
no
have revenge.
question
Our
to you.
justice delivery system
Why-
is not
why
revenge
should
based.
this
Yeah, we've
It is
seen
justice based.
Yes,
It's punishment
Brinda.
based.
Yes, Brinda.
forgotten.
Yes,
Have his
Brinda.
family
And retributive,
to come
both.
and meet him, love him.
Yes,
The
Brinda.
relationship will continue at the state's at my expense, at my tax
And you know,
expense.
Purnima, and you
when
know,
the other
Brinda Adige.
family has lost their daughter.
Yeah, we've seen what's
No,
happened
no,
in the case
in
of
the morning,
no,
two
no,
rotis
I
in the
don't,
night doesn't
sir,
cost much.
not
What are
one
you
single
talking
naya
about?
paisa of my taxes do I want it to go for a person like Ankur
You
Panwar. I don't
him
want
to-
them, but
you
I don't
him
want
to
such
set an
elements in
example.
society,
His
sir.
case to set an
There are
example.
many who
That
feel,
your
sir, there are
mother
many
is
who
also
feel
there.
they don't want such elements in society at all. Society needs to be rid of such elements. Be in jail or outside jail is irrelevant, Purnima Advani.
Purnima Advani, go ahead.
See, the question is,
Will you-
the question
will you
that,
guarantee-
that he could have been reformed is a larger question, and therefore death penalty should be removed from the statute book because anybody can be reformed.
says that?
But the point here is that till death penalty is there, and this being a very, very grave, heinous offence against a young woman, the law should enforce itself most strictly, and there should be time-bound judgment even from the Supreme Court confirming this. And that's extremely crucial if at all message has to go. See, when I was the chair of the National Commission for Women, we came across some such very serious attacks of acid. Even in Shimla, we had investigated such case. And we had recommended to the government that till the death penalty is on the statute book, please treat acid attacks leading to death as equally
Yeah,
serious.
and you know, Swapnil, there
And
needs
let
no,
there
no.
not be any
Coming back to what
leniency.
Sujay was saying.
Otherwise, the message becomes loud and
Exactly,
clear
the message.
that
Speaking about the
criminals
message.
can just be on
Speaking-
bail for years on end. And
Exactly.
can
Yeah,
escape
she's talking about the
scot-free
message that
ultimately.
needs to be sent
And
out.
the woman is
Correct?
unable
No, no,
to leave her
no,
home.
one fact, one fact and I'll give it to you.
Go ahead, go ahead.
That
One
she
fact and
just
I'll hand it to you.
can't face this world.
Got it. Purnima Advani.
She is doomed from day one.
Exactly. The message has to go out. There's a reason why this should be an example.
Right.
There's a reason. He should be made an example of, given the fact that acid attacks in 2014, I have the facts from 2014, jumped by almost 300% than the preceding 3 years. By 300%. And why shouldn't this case be made an example out of, given the fact that the latest records show that 309 victims of acid attack were reported across the country as per latest data.
So exactly what
You have the numbers.
And this
But
is
you have the
just
facts and
going
figures.
by-
Provide for a
What
death sentence
Purnima
for
is
acid attack.
cautioning against.
The maximum sentence prescribed under statute for acid attack is life imprisonment. The present case he's been granted death only under the section of 302, that is murder.
Yeah, 302.
Yeah,
but
because
the
it
fact
is cold-blooded
because
murder.
it is cold-blooded
It was
murder.
planned. It was
And the
planned.
aggravated
It
circumstance
was
of
planned.
throwing of
Sumit
an
Verma, he
act
travelled
that
from
could
Delhi
result
to
in a finding
Mumbai
that
with 2
qualifies
liters of
as stuff.
sulfuric acid. Chased this woman the moment she stepped out of that Garib Rath at Bandra terminus, stepped foot onto
Therefore,
Mumbai. He
qualifies
threw
as
the acid on her with the intent of maiming her for life, and it took her life. And he shows no remorse. He said she does not deserve to live without me.
Offense of murder is satisfied.
He said she does not deserve to live. I will not let her live without me.
If there is a possibility or the probability of rehabilitation or reformation, then
Yes.
the law prescribes a life sentence.
Yeah, the
Sumit,
law-
I
Death
understand.
sentence.
Sumit, if you
All
drive,
I'm saying is,
Sumit,
that the
can you hear
court
me
was
out, please?
supposed to follow that procedure before,
Correct. The
entire
law,
interpretation.
before
sir, the,
giving a finding of a death.
yeah,
Sumit,
Yes.
he's going. Sumit, I understand what you're saying, but are you trying to tell me that if I drive a car in a crowded marketplace, I'm responsible only for negligent driving, but not for death? Can I not assume that if I drive a car in a crowded place, the people won't die? This is the same thing. If I throw an acid on a person, the person is dying. So that's why 302 was levied.
If a person
Now that is
dies,
one aspect.
then you would be
The other
liable
aspect
for
is
causing death
the
by
other
negligence
aspect
and
is
rashness.
Purnima.
You
What
will not
Purnima
be,
is cautioning
liable
against
for
is
murder
that
Sumit
that
Verma,
you are
Sumit
the
Verma,
facts,
let
what
me
is-
ask you this
that
straightforward.
You are so rash, and so
Sumit
negligent
Verma,
that
let
you
me
had
ask you
inherent
this
knowledge
straightforward.
that the man would die on street.
How much time did that man take to throw 2 liters of sulfuric acid on the woman? How much time?
I am not
30
for
seconds.
a second defending
30
his action or
seconds.
saying that he does
And in
not deserve
30
to
days,
be convicted of the offence of
after
murder.
30 days
What I
of
am saying
pain,
is,
agony,
what I am saying is, having
ignominy,
returned a
and-
finding of guilt of murder,
and also the tragedy that the parents, the trauma that our parents had to face, the family had to
Yes.
face, and the apathy
And they
that
continue to face in court.
apathy that they had to face.
so therefore,
No.
therefore,
In a few
therefore,
seconds.
all
In a
these
few
factors
seconds.
taken together
And how much time has it taken to
what
even?
precluded the
How
trial
much
judge
time has it
or the
taken even for the
prosecution
lower court
follow
to
the
pronounce a
procedure
verdict,
in order
sir?
to ascertain, in
How
order to
much time
ensure
has it
that
taken?
the death sentence
How
not
much
held
time? Sir, the
confirmed by
more
the
you
High Court.
try, the
If
more
they
you
do not
try.
follow the procedure, it will not be confirmed. What is the good purpose of having a debate over death
very good. So
sentence?
somebody can throw acid. Somebody can throw acid and then hire a top-notch lawyer, a defense lawyer, and that a lawyer will prove
No,
that the
no,
acid,
certainly
the
not.
acid,
All I'm saying
the
is
fact
that
that
the
the acid
prosecutor
landed
needs
on
to
the girl
perform
is
his
the
duty
acid's
of
fault.
giving
It's not the
additional
guy's
evidence.
fault. That's what they will argue
Then the
about.
trial judge has to perform a
Murder.
duty of returning a finding.
No,
that he
come on,
cannot be,
don't.
rehabilitated and reformed.
Please don't.
Sir, you can't. I mean, I'm sorry,
Sumit,
sir.
come on.
The trial judge has given a finding of guilt.
Such people
not
should not be
disputed,
defended in the first
debated
place.
today.
Such people should not be defended
No,
in the first place.
I am not
Secondly,
for a second
you're
saying
trying
that
to
he
tell
needs
me
to be defended.
it has
All
taken
I'm
3
saying is
years
that
for
the
a lower
trial
court
judge
to
has an
decide
option between
this.
life sentence and a death sentence.
It has taken 3 years
He is
for a
given a
lower
death
court to
sentence
decide that this
without
person is
following
guilty.
the due safeguards
This
in law.
after the investigators fumbled, the High Court came back and said, go back and revisit the case and reinvestigate the case. That is how much of
And
trauma
therefore he was
the
rightly
family
convicted.
the family has had. That much, how much the family has to go, trauma that the family has to face in the legal system of justice within our country, sir. So today, let's not challenge this death sentence because at least one family out of many has got speedy justice. Speedy, just 3 years. 3 years is speedy justice in our legal system.
And
That's the irony, sir.
The point which I wish to make
for the
is,
benefit of the
however
viewers,
much you
what
may defend
Purnima
the
was
death
cautioning
sentence
against, that
granted by
the
the
court
trial
should
court in this
confirm
case,
this
what is
sentence
the good
without
use
any
if it is
further
not
delay,
confirmed by the High
is that
Court?
she was trying to say that Indira Gandhi's
The trial-
killers
if
were
the
let
trial
off
judge
because
does
they had
not
already
follow
served 20 years in
principles laid down by
jail.
the
So what is the
Supreme Court in a number of
point
cases,
that giving a death
the
penalty to them would
prosecutor does
amount
not
to
need
double
additional
punishment,
evidence at
which
the
is not
stage of
allowed in law?
sentencing. It will not be
That is
upheld
exact.
by
So
the
what
Higher
she's
Court.
cautioning against is that, and if Sumit and with due respect to you, Sujay, if you all are saying that an eye for an eye only gives you a nation of blind men, as enunciated by Mahatma Gandhi, I disagree with him because it's better to have blind men than to have burnt women.
No, but in our system now, after this judgment, there is an appeal to the High Court, and High Court is going to admit it. In capital punishment cases which are awarded by lower court, it is mandatory that the appeal
Yes.
should be admitted because
It'll go
there
to High
could be a
Court, it'll
chance
go to
of
Supreme Court. If it doesn't work,
No, but
it'll go
that
to
is
the
our
President.
system, my friend.
Exactly.
That is our system, is,
Yeah,
and
yeah.
we have to follow the system.
We have to.
You can assume.
But I'm only arguing
assume
about-
a case
we'll fast track
that
it.
see 99
The
guilty
media
may
will
go,
assist in fast
but one
tracking.
innocent should not. So what I'm trying to say is that there has to be a rule of law followed. The system has to be followed and reach a logical end. That is all I'm
Exactly.
saying.
Like in this case, the law has been followed.
The law has been followed, but
Yes.
but
So you
I have
can't
one
even
thing to
argue
say.
that.
I have one
Sir,
thing to say.
I don't know. When I'm thinking it from the point of the victim, this is gross injustice. Within 30
very
seconds,
sad.
within 30 seconds, my life is gone. Within 30 seconds, my life is gone. I have been maimed for life, dismembered for life, disfigured for life, and I have to live with this every single microsecond of my life going forward. And look at the condition of this person. He's got the right of law. He's got the fact that everybody will defend. All sorts of procedures have to be formed. Every single piece of evidence will be shredded and torn to bits. And what has happened in front of everybody will have to be proven.
No,
How is this
very-
justice?
It's very sad what has happened.
No,
to
no,
her.
how is this justice?
Very
And
sad
then
what
there are
happened to
people
her.
who say
There's
that
no
somebody
doubt
who's
about
been
it.
awarded a death sentence for such a crime like this, such a heinous crime like this, you have to then wait and see whether due law and due procedure has been followed, because it is unjust and unjust that this person is getting a capital sentence. Imagine, I'm just thinking, I can't even go
But
through,
my
I can't
friend-
even
but listen to
go,
this.
go to an ounce of what a person who's gone through this tragedy. थोड़ा सा हाथ जल जाता, बैंड बजाते हमारी sir.
No,
Look,
I
look
agree.
at them. Look at them.
I agree.
For no
I
fault
think-
of theirs.
I think you put it in
You
the most
snatched their
profound
life
manner.
away.
You put it in the most profound manner. It really touches the heart. But let me say this: rarest of the rare. Let us go back to the top. Rarest of the rare, death penalty debate. The Supreme Court has said there is no straitjacket formula to decide what is a rarest of the rare. I'm not trying to support this person. All I'm saying as a lawyer on the debate is with my friend that let us read the judgment. Let us see
Supreme
how
Court has
the
spoken
judge
about
has-
special reasons. Supreme Court has spoken about special reasons.
reasons.
Sir, such
Why
monsters
can be
deserve no
registered
mercy.
behavior, demeanor,
Sir,
all those things.
such
I
monsters-
would like to
No,
bring to your
leave-
notice.
No, I'm sorry. I'm sorry.
My question,
The
no, I'm sorry.
my question to my fellow
deprives
panelists is
this
only what
victim
does he
of
want
her
to see in
life.
the judgment?
Deprives the family
What
of a
do you
loved
want to see?
one.
What reasoning do you want to
The
see?
family
whether
I mean, there is a
believes
reasoning
begins-
that's just there.
Whether the judge has followed the formula and what the judgments of the Supreme Court have laid down to bring it in the rarest of the rare cases.
Correct.
And that is why she will justify
Yeah.
on the basis of the arguments of the prosecution, because I'm sorry I'm repeating myself, but the job of the prosecution is not to secure a conviction. Supreme Court says prosecutor's job is not to secure a conviction, it is to assist in the course of justice. And this can't be a revenge based justice.
The judgment
It has
will
to
not-
be-
the
Sir,
judgment
if it
will not
was,
take
sir,
away-
if it was revenge
Sorry.
based, it wouldn't have gone on for 3 years. It wouldn't have gone on for 3
You have
years,
to-
and it would have gone through the entire course of law and so many hearings.
And just one last point I want to make to you. The judgment, whatever the judgment says, will not take away from the reality of the crime committed. The judgment, whatever it says, will not take away from the reality of the crime. And I just want to end by saying one thing, this 28-year-old, after whatever he's done, remember he put the blame on the family, calling it a case of honor killing.
Yes.
That's the mindset that we're talking about. And that's the reason why an example should be set. And that's why we're questioning those.
I do not
Exactly.
want. We
That's
do
why
not
we're
want to
questioning
see
why
this man flashing that
rehabilitation
victory
argument.
sign.
Absolutely. And it's a deranged mind. It needs to be shut out.
This person should not
And I
be
think
flashing the victory sign
we'll
like
just
this.
play that picture one last time before we thank our
That
panelists.
is a picture we don't want to
That
see.
picture speaks about a man who threw acid on a young girl who came to Mumbai pursuing her dreams.
To
She
work
was-
for the Indian Navy as a nurse. And as she stepped foot in Mumbai at the Bandra terminus, her life was taken away by this man.
With that, we've come to the end of Debate 2 on the News Hour tonight. Thank you for joining us.